Good evening and happy Friday. I hope you're doing something fun and exciting for your Friday and you're watching this at some later date. That would be great. So I have indeed acquired Legally Departed. Thank you, Chili. I'm going to pretend you gave it to me. And I'm only going to review a couple sections out of it. Just a couple. I'm not going to do the whole thing. But I figure I would save that for the end. And we'll start off. There are two trifolds that Chili offers, and he offers them in black or white, because you got to keep it classy, I guess. So despite the fact there are four, there are really only two that we're going to look at. We're going to look at the black ones, just because. I don't know why. I prefer a black background. It's kind of like the night settings on YouTube. It's just a little easier on the eyes. So the first trifold we're going to look at is this one. And we're going to just quickly go through it to see how useful this trifold is. The first case is that he puts up here is Houston v. Hill. So right out of the gate, it is a Supreme Court case. So no matter where you go in the country, this will be applicable. Now, remember, just from the get-go, just remember that 90+% of all cases are going to be in state courts. And each state has their own understanding of what the various constitutional provisions of the U.S. Constitution mean. Now, they have to have their decisions align with the Supreme Court and federal courts that are in their particular circuit, but they will have their own rulings that interpret it because the U.S. Supreme Court hasn't interpreted any amendment of the Constitution to apply to every particular fact pattern. So the majority of cases that you're going to deal with at any given time are probably going to be at the state court level. Even interpreting U.S. Constitution, you're going to be dealing with a lot of state court decisions. The next most common thing you're going to deal with are circuit court decisions. Federal circuit courts, if you're I'm in the Ninth Circuit, they are going to have dealt with a lot more issues involving your constitutional rights than the Supreme Court does. The Supreme Court has dealt with very few cases compared to, for example, the Ninth Circuit or the Fifth Circuit. And so while the circuits have to align their cases with what the Supreme Court has held, there's always going to be more clarity, it's going to get a little bit more granular as you go down the chain than as you go up the chain. So whether or not you'll ever have to reference Houston versus Hill in any pleading is, very slim. Even as an attorney, the odds you're going to be referencing it are very slim. And you're going to have the right fact pattern. So in this, it says, held a certain amount of expressive disorder is inevitable in a society that's committed to individual freedom and must be protected if that freedom would survive, First Amendment. And then it says, fact, interrupting police is your God-given, or is your right given by God. The issue in Houston versus Hill was there was a municipal ordinance that made it unlawful to interrupt an officer in the performance of his or her duties, and the court found that was unconstitutional. Whether or not that means that interrupting police is your right given by God, I don't think so. And I think that there would be instances where interrupting the police may, in fact, be a crime. So, does Houston v. Hill hold that interrupting police is your right given by God? No, it doesn't. You could still go to jail for it, potentially. Next one we have is Chaplinsky versus New Hampshire. The charge was offensive words. Held certain words are exempt from 1A protection, First Amendment protection, when they instigate violent reactions by listeners. Fact, you damned fascist or you goddamn racketeer are labeled as fighting words by SCOTUS. Well, okay, in this particular instance, those words were labeled as fighting words by SCOTUS. It doesn't necessarily mean that those Like if you walked up today to a cop and said, "You damn fascist," that's probably not fighting words. It's probably not. If you walked up to a black guy and you started yelling the N-word at the top of your lungs, that could be considered fighting words. So it all depends on context. Oh, it says down here, I can and I will use any words or set of words that I feel are appropriate. Fighting words are clearly not the words I'm using. I don't understand what he's trying to say there. I guess he's giving you something to read and fantasize about saying if you ever get into a confrontation with the police or something. So so anyway, where you would see fighting words nowadays is in disturbing the peace statutes or disorderly conduct statutes, where they can outlaw words that tend to incite an immediate breach of the peace. It doesn't actually have to cause someone to start swinging at you, but it has to be language that tends to incite the ordinary person to an immediate breach of the peace, to want to get into a fight. The next one we have is Tech Lines versus Danforth from 1943. And that one was a bit of a sticky wicket for me to find, but I ended up finding it. You know, I remember once upon a time, James Freeman was posting some real sovereign sit stuff, and he put up a gish gallop of cases that allegedly were Supreme Court cases that stood for the proposition that you could drive a vehicle, you could operate a motor vehicle or pilot your vessel or whatever they want to call it without a driver's license, and that there was some constitutional provision against having driver's license. And the majority of the cases they cited were, oddly enough, not Supreme Court cases, but they were things like Supreme Court of a state kind of things. And this is another one of those things. So I don't know how much help for you Tech Lines Incorporated versus Danforth is going to be. It is highly dependent on whether or not you're in Mississippi and whether or not it's still good law. And I honestly don't know and don't care whether or not Tech Lines Incorporated versus Danforth is. So I'm just going to completely disregard the holding and the facts in it, because I'm not in Mississippi, and I don't think a lot of my viewers are in Mississippi. And yeah. So then now we have U.S. versus Williams. That is this one. The charge was distribution, and held because the subject of a consensual search has control over the search parameters, he can restrict or terminate it entirely. Fact: to revoke consent to clear a search, you must make a clear, unambiguous position. That is a very poorly worded sentence. But yes, if you're going to revoke your consent to a search, you do have to be clear and unambiguous about it. So great. Your best position is to never consent to anything. Don't talk to the police. Ask for an attorney and invoke your right to remain silent. Next one we have is I smell marijuana, Commonwealth versus Barr. This is another one of those that I had a real hard time finding because it is a Supreme Court of Pennsylvania ruling. Now, this is at least a 2021 Supreme Court of Pennsylvania ruling, so it's probably still good law. I don't know. I don't really care. If you're in Pennsylvania, I haven't read the decision, but you might want to read it, maybe talk to a local attorney. It might apply to you. To most people, it doesn't. The next one we have is simply titled Fifth Amendment, right to remain silent. Held. No person shall be held to answer, I think that means to answer, for a crime. You know, if you're going to charge someone like $16 for these things, or however much he's charging, you should proofread it. I mean, I'm just guessing if you're gonna have it laminated with a trifold or whatever he does, proofread it. Is that so hard? Proofread it. No person shall be held to answer for a crime or be compelled to be a witness against himself, nor be deprived of libert, sans due process of law. I want my libert. I don't want to be deprived of my libert. Fact, 5A applies to more than merely defendants. A witness may refuse to answer questions to avoid self-incrimination. Generally speaking, yes. Generally speaking, you do have a right to remain silent. I say generally speaking because there are instances, for example, if the prosecution wants to have you as a witness in somebody else's case, and they say, I'm going to grant you blanket immunity for whatever you say, nothing that you say on the stand will ever be used against you, then the court may be able to compel you to testify because you're no longer going to incriminate yourself because you have blanket immunity. So be aware of that. Talk to an attorney. That's what attorneys are for. General statements like this, and coming from a guy who mixes in two cases in the previous one, a Commonwealth versus Bar and Tech Lines versus Danforth, that aren't applicable to 49 states and may not even be applicable in the case of Tech Lines in Mississippi still. I mean, you're rolling the dice. All right, next one's Cohen v. California, one of my favorites. Cohen v. California, charge disturbing the peace, held. Justice Harlan, one man's vulgarity is another man's lyric. Was that really the holding of the case? I don't think it was the holding of the case. I think the holding of the case was something like, absent a more particularized and compelling reason for its actions, the state may not, consistent with First and 14th Amendments, make the simple public display here involved of the single four-letter word expletive a criminal offense. Because that is the only arguable sustainable rationale for conviction here at issue, the judgment below must be reversed. So what it held was that you can't criminalize profanity in and of itself. Now, again, you can go back to fighting words, and shouting the N-word at a black guy you might be able to criminalize that under the disorderly conduct, fighting words. So it says, fact, by choosing these words, you get to know the depth of my feelings. Brandeis formula says free people have access to all materials and to all words. Again, grain of salt. It could blossom into fighting words. So just be careful. Be careful. Next one we have Terry v. Ohio. Held, a reasonably prudent man would believe you're armed and dangerous and a threat to officer safety. I don't think that was the holding. I don't think the holding is that every person, a reasonably prudent man would believe that every person out there is armed and dangerous and a threat to officer safety. I could be wrong. I think it held that reasonableness is the touchstone of the Fourth Amendment. And if a reasonably prudent person, given the facts that the officer has and the officer's training and experience and ability to interpret those facts, could a reasonably prudent person believe that crime is afoot? And if so, is that person armed? And I'm butchering it horribly, of course, because, it's long and I'm summarizing it just by having it up here on the screen, not having read it in a long time. But it's something along those lines. It says, fact, temporary detention is not the right to search and seize. It is the right to investigate, not to touch me. Well, so in Terry v. Ohio, what Officer McFadden did and what the court ended up finding was constitutional is that he seized Terry. He literally pushed him into a shop, and then, guess what, kids? He frisked Terry. Frisking involved him patting down Terry's coat and sticking his hand into Terry's pocket to pull out a firearm. So it literally was the right to touch him. And now under here it says, I do not answer questions and I do not consent to any searches or seizures. I am not discussing my day or plans and reserve all rights. Well, I guess I'm not answering questions and I don't consent to any searches and seizures is fine. I don't have any real problems with that. I think at that point you should just stop. Once you invoke your right to remain silent, you should just stop. Next one up is our good friend Turner v. Driver. So this is applicable to the Fifth Circuit. This is persuasive to other circuits, but it's not precedent to other circuits. It is also binding on any of the states that encompass the Fifth Circuit, as far as their interpretation of the First Amendment. Now, it says, held officers lacked probable cause to detain. Okay, I think the more important thing that it held, I think the issue that's most important to this community that it held was that you have a right, subject to reasonable time, place, and manner restrictions, to record the police in the performance of their duties. And yes, it is very clear that you have the right, subject to reasonable time, place, and manner restrictions. We conclude that First Amendment principles, controlling authority, and persuasive precedent demonstrate that a First Amendment right to record the police does exist, subject only to reasonable time, place, and manner restrictions. And then it ends with that. In this case, this right, however, is not without limitations. Like all speech, filming the police may be subject to reasonable time, place, and manner restrictions. In this case, however, we need not decide which time, place, and manner restrictions would be reasonable. Nonetheless, we note that when police departments or officers adopt time, place, and manner restrictions, those restrictions must be narrowly tailored and serve a significant government interest. That said, to be constitutionally permissible, a time, place, and manner restriction need not be the least restrictive or least intrusive means of serving the government's interest. So yes, it is 100% subject to time, place, and manner restrictions. The Fourth Amendment stuff I don't think was nearly as important, but sure, they did not have probable cause because they couldn't articulate anything that he was doing that was a crime. So it says fact. First Amendment principles, controlling authority, and precedent demonstrate the right to record the police does exist. And see, that he left off the most important thing, subject to reasonable time, place, and manner restrictions. It's not a completely unrestricted right. He goes on to say, my God-given rights are validated in Turner. Years of case precedent clearly establishing the right of citizens to record police in their official duties. I don't know why he has to say God-given in there. I think it was given by the U.S. Constitution, but I don't know. Next one, he says it's U.S. v. Carroll, which threw me off for quite a bit, but I ended up finding it. It's actually Carroll versus United States. This is a 1925 case. I'm not sure. Well, no, it is still good law. No, I remember this one now. It is good law. I actually remember this one now. Yeah, okay. So it says held. Primary reason for a warrantless search is to seize alcohol to stop loss of life or hot pursuit. Fact. Cops can search if they have probable cause you're transporting liquor. I believe the holding in Carroll versus United States, and I could be wrong on this. I haven't read it in a long time. I think this is one of those ones where it deals with a vehicle exception to search warrants. Because vehicles are so mobile, they're generally, there is an exception to the search warrant requirement because you could just drive away. So homes are always, you need a search warrant basically you're going to need a search warrant. There's a few exceptions, but with homes, you're going to need a search warrant. Cars, not so much. Now, if they impound your car, or excuse me, maybe not they impound your car, but if your car's up on blocks or something and it's not in danger of being driven off, then maybe they have to get a search warrant. If it's prudent to do so, they need to get a search warrant. But if it's a situation where you can just drive off, then there is an exception to it. They still need probable cause, if I remember correctly, to search, but they don't need the warrant. So it says cops can search if they have probable cause for transporting liquor. I don't think that is very accurate. Just like if I stop at the store and I have a 6-pack of beer in the back, but it's clearly not opened, they can see through the windows that the cans haven't been popped yet. I don't think they have a right to search at that point. This was back in the day when bootlegging was a thing. The Carroll doctrine is quite clear. The reasons you can warrantlessly search my cars to prevent loss of life, hot pursuit, or to seize illegal alcohol. I think it's if they have probable cause that you have some sort of contraband. I think that's where it is. If they have probable cause and getting a warrant wouldn't be feasible. The next one is U.S. v. Bradley. This one is a United States District Court decision in the District of Oregon, which means that even in the District of Oregon, this is just persuasive. It's not precedent. It's literally only precedent for state courts. In Oregon, I think. I don't even know if, I don't even know if this would be binding on... I don't even know if this would be binding on state courts, to be perfectly honest with you. I'd have to have a think on that, maybe a Google on it. But this is about the least persuasive thing that you can get in the federal court system because it is just a district court. It's not a circuit court. It's not a court of appeals. It's not a circuit court. It's just a district court. So, it's published, but it's just persuasive. It's not precedent. It says there can be no effective... I haven't read it, so I don't know if it's true, but we'll just look at it to see if it sounds reasonable. There can be no effective search consent when cops assert it is their independent right to engage in the search. A closed container or compartment means a container whose contents are not exposed to view. Okay. The Ninth Circuit has said it is well established that there can be no effective consent to search and seizure if that consent follows a law enforcement officer's assertion of an independent right to engage in such conduct, citing or Hog versus Immigration and Naturalization. So instead of citing U.S. v. Bradley, they should have cited Orhog or Horhog, because at least this one is binding. This is precedent, so this is binding on the states and on the district courts. So that's dumb, but apparently it's correct. The holding there is correct. Arizona versus Johnson. That's our last one, and. It says a roadside stop begins when a vehicle pulled over for traffic violation. A lawful roadside stop begins when a vehicle pulled over for a traffic violation. That's a terrible sentence. Passengers can be patted down if prudent. I think the Terry frisk stuff, I think they still have to have reasonable suspicion that the passengers are armed. And then it says, fact, passengers do not have to show their ID. It doesn't hold that. Arizona versus Johnson does not hold that passengers don't have to show their ID. Passengers may have to show their ID in certain circumstances. Now, typically vehicle codes only require drivers to show their driver's license because they're operating a vehicle, so they have to show their driver's license. But there are also criminal codes out there, or criminal procedures, or whatever it is that gives you things like HIBL, where Nevada has a statute that requires you to identify to police if they have reasonable suspicion. And so if the police have reasonable suspicion that you have committed a crime, are committing a crime, or are about to commit a crime pursuant to Terry v. Ohio, this bad boy up here, and if there is a state law that says that they can ID you, that you have to give them ID if they have reasonable suspicion, then passenger may have to show their ID under that particular set of facts. So, again, it's maybe not the most prudent thing to do to rely on a card where they get so many things wrong. Unless there's probable cause that I have committed a crime and you are placing me under arrest, I'm not required to provide ID even in stop and ID states. Again, some stop and ID states have statutory authorization that require you to ID if the officer has reasonable suspicion, i.e. see HIBL. Anyway, so those are the trifolds. They're, in my opinion, not worth $15.99 for the I don't know, whatever we called them, indestructible ones. But then let's get on to legally departed. Now, I promised I would only do a couple sections, and I've chosen 2 sections to do. And they are these 2 sections right here. We have Bad Elk versus United States and US v. Caroline Products. So, Bad Elk versus United States. What he says in his book, and you can see the illustrations in his book, they're all fairly similar to this, although a lot of them have people who have been killed recently in contact with the police. There's your obligatory George Floyd. So, there you go. There's the art. So he says that Bad Elk says you have a right to resist a warrantless arrest. And I don't think so. I don't think so unless your state gives you that right. So I made a video on it. Bad Elk is bad law. You can watch it. You can see here on the screen, I've selected this particular section just for this. This is Westlaw. You can see on Elk versus United States, this is Bad Elk. There is a big red stop sign. There is a big red stop sign. This is not good law. This is not good law for a bunch of reasons. Just real quickly, again, there's an 8-minute video you can watch about it. Real quickly, number 1, there is no more common law. There is no more federal common law. And number 2, the only reason why we would even talk about federal common law was because this particular act where Bad Elk defended himself took place on an Indian reservation, which is subject to federal law. Indian reservations now have laws that are either passed by the tribe itself or there's a default set of laws that are federal. There is no more common law that governs Indian reservations. So Bad Elk would have applied to Indian reservations and other places where there were no laws in place superseding federal common law, but there is no more federal common law. There is no more federal common law. So Bad Elk is not applicable. 8-minute video, link will be in the description. If you have any questions, watch it. It will explain it. It is no longer good law. So telling people that they have the right to resist a warrantless arrest, first of all, no. So even that, Bad Elk was about resisting an unlawful arrest, not a warrantless arrest, an unlawful arrest. So an officer was not authorized to make an arrest without a warrant, well, for a mere misdemeanor not committed in his presence. Well, it was an unlawful arrest. That's the big thing. Anyway, my point is, even it doesn't really matter. It's bad law. It is no longer controlling for anything. And then the second one, this is I don't even know what to think about this one. This is an actual U.S. Supreme Court case. I opened it up and looked at it. I don't have it up, but this is what it has. I mean, I'm not skipping anything. That's page 37. This is page 38, 37, 38. 1938, U.S. versus Caroline Products. 5-3 decision for the state. Opinion by Harlan Stone. Okay. Well, this must be important, right? Footnote 2 and 3. Butterfat, which constitutes an important part of the food value of pure milk, is rich in vitamins, food elements which are essential to proper nutrition. There is now an extensive literature indicating wide recognition by scientists and dietitians of the great importance to the public health of butterfat and whole milk as the prime source of vitamins, which are essential growth-producing and disease-preventing elements in the diet. Okay, bro. I don't even know what to say. And then there's a double footnote 4. I don't know why. And, there's 39. I don't know. There's a double footnote 4. I guess he really wanted to make sure that you read this particular footnote. There may be narrower scope for operation of the presumption of constitutionality when legislation appears on its face to be within a specific prohibition of the Constitution, such as of the first 10 amendments, which are deemed equally, and then one is highlighted and the other is not. So I don't know. Specific when held to be embraced within the 14th, it is unnecessary to consider now whether legislation which restricts those political processes can ordinarily be expected to bring about repeal of undesirable legislation is subject to more exacting judicial scrutiny under the general prohibitions of the 14th Amendment than are most other types of legislation. Okay. But remember, kids, butterfat's good. Or something. I don't know. Anyway, so there's your review. I didn't think it was very helpful. I appreciated the knowledge about butterfat, but bad elk is still bad law. So, sorry, Chili. I don't believe that your book legally... Oh, and that's another thorough thing. Everybody, he has their dates and he has them all. It says legally departed. I think they're dead. I don't think they're just legally dead. I think they're actually dead. So anyway, that's the review of Legally Departed and of Chili's Trifolds. Save your money, kids, for a good lawyer. If you're playing those silly games, you're going to need that money for the silly prizes. Thanks and have a great night.